Good morning. This is a second public hearing before the Office of Medicaid Policy and Planning on the 29th day of April 2024 at 10 a.m. at the Indiana Government Center South, 402 West Washington Street, Conference Center, Room 1, Indianapolis, Indiana, with a remote attendance option via Zoom. This proposed rule will amend 405 IAC 2 concerning updated definitions, guidance, and clarification of terms, and will align IAC with federal code. Notice of time and place of this hearing was given as provided by law by publishing on March 20th, 2024 in the Indiana Register. My name is Amanda DeRoss, and I have been appointed hearing officer by the Office of Medicaid Policy and Planning. As the hearing officer, I will not answer questions or provide comments on the proposed rule during this public hearing. The sign-in sheet should be completed by all individuals desiring to be shown as appearing of record and shall be completed by those who desire to be heard during this hearing. If you have not already signed it, please do so at this time. If you're joining via Zoom, please use the chat feature to write your name and affiliation in the chat box. I have copies of the proposed rule here, which you're welcome to take a copy of, or you can find it online at FSSA's website at www.in.gov/FSSA under rulemaking notices and updates. Oral statements will be heard today, and written statements may be handed to me or emailed to me at amanda.deross@fssa.in.gov or mailed to me at FSSA, attention, Amanda DeRoss, 402 West Washington Street, room W451, Indianapolis, Indiana, 46204. Correspondence should be identified with comment regarding LSA document number 23-819. Comments will be accepted until the end of today, April 29th, 2024. Each person who speaks for the record is requested to clearly identify yourself by giving your name, spelling it, and identifying who you represent. For those on Zoom, your microphones are currently muted. If you would like to make a comment, please use the raise hand or chat feature to let us know, and we will unmute you. Is there anyone who cares to be heard? I think to this, see the.
Your other channel.
Yes, yeah. Okay, I think you unmuted.
Yes, can you hear me? Can you hear me? Okay, I can't hear you guys now.
We can hear.
Okay.
Yes, we.
Okay. My name is Jesslyn Smith. I am currently serving as the president of the Indiana chapter of the National Academy of Elder Law Attorneys. We are a nonprofit association of lawyers who work with older clients, people with special needs, and their families in Indiana. Our members' services include planning for the cost of long-term care, benefits, entitlement, eligibility, including Medicaid and Medicare, guardianships and probate, special needs planning, estate planning, and other legal issues that affect the elderly and disabled. We regularly counsel and assist the elderly and disabled with Medicaid eligibility. We are wanting to submit additional comments for this LSA document 23819, specifically concerning the community spouse IRAs. The federal law on spousal impoverishment defines resources as not including resources excluded by the SSI statute at 42 USC 1382B-A or D, but CMS did state in their opinion to FSSA that community spouse retirement accounts are excluded by a separate section, which is 42 USC 1382CF. Consequently, the state can choose to exclude community spouse retirement accounts, but it does not have to exclude them. The Social Security Administration explained that in their reasoning back in 1987, excluding an ineligible spouse's retirement account when publishing 20 CFR 1202A1 to exempt these funds as follows. We believe it is inequitable to jeopardize the future of a person whose resources are deemed so that another individual's current needs can be met. In order to be supportive of families, we believe it is preferable to permit a spouse or parent to provide for his or her own future while recognizing the current needs of the otherwise eligible individual. Therefore, we will not count pension funds owned by an ineligible spouse, ineligible parent, or ineligible spouse of a parent. Pension funds were previously the retirement vehicle employers used for their retirees. With the shift to the individual retirement accounts, these accounts have largely replaced employer pension funds. However, the concept between the two remain the same. They are a vehicle for retirement savings for folks when they retire. If the Social Security Administration and the reasoning believed it to be inequitable to count an ineligible spouse's pension fund, the reasoning should apply to individual retirement accounts of an ineligible spouse as well. We understand the FSSA is wanting to implement this rule, but and this is from our continued discussions and efforts with FSSA officials, but our chapter would recommend some implementation suggestions that we strongly recommend that FSSA should consider. At minimum, we believe that FSSA should implement this rule change at a future date farther out than August 5th to allow stakeholders time to educate other stakeholders and the public of the change being implemented. We believe, we strongly recommend this should be pushed out to the beginning of 2025. Proposed language to be added could be effective for applications filed on or after January 1st, 2025. When the computation of the spousal share at the time of institutionalization is calculated under 42 SC 1396 R5C1, retirement accounts either or both spouses have an ownership interest in are included in the total value of resources. We believe that the state should take time with stakeholders to implement language to add to the rule to set a dollar amount that individual retirement accounts can have and still be considered exempt. For individual retirement accounts with values equal to or higher than the set dollar amount, the individual retirement account would count as an asset in determining resource values for community spouses. We strongly encourage FSSA to work with stakeholders to implement the language to be added, stating this dollar amount. As currently written, we also strongly encourage and recommend that there will be, or we believe that there will be some confusion as to the application of the rule for snapshot date values. There is a disadvantage created by this rule for individuals that have snapshot dates between 2014 and the date the rule would be implemented. We believe FSSA should work with stakeholders to add language to the rule that will make it clearer concerning snapshot dates established prior to the implementation. Through our continued efforts with FSSA officials, we also believe and strongly encourage and recommend that considerations discussed in meetings with the FSSA officials, including a recent meeting with Secretary Rusniak, with Senator Walker, also be considered. And we believe that FSSA should slow down the efforts in which to implement this rule change. We also further believe with regard to the changes recommended for personal service contracts or personal care agreements, to also look at implementing a specific date in which the rule would apply to contracts created on or after a specific date. We also believe that this date should be a further date out, also giving time for stakeholders to educate the public and other stakeholders. And then we reserve also to be able to submit written comments as well by the end of the day. And that's it.
Great, thank you. And you do have until the end of the day to submit a written comment.
Yes.
Great, is there anybody else who cares to be heard? I don't think I see anybody else on. Okay. Well, seeing and hearing no one else who cares to be heard at this time, I want to thank each of you for your attendance. The time is now 10:12 a.m. These proceedings pursuant to notice are hereby concluded. This hearing is therefore adjourned. Thank you all for coming.